Welcome to Cut to the Chase, where we talk about compelling legal, regulatory, and public interest information and news. Your host is Greg Goldfarb, an attorney, entrepreneur, investor, and activist.
All right, now we're back to part two of this business information episode podcast with Lawrence Lambert from Miami, UVA, University of Virginia, A Pi fraternity brother, and also a member of Temple Judea. I don't know if did I cover everything. And we're going to cut to the chase. In episode one, we talked about the beneficial ownership issue that a lot of people are starting to be like, oh my God, what do I have to do? I'm in a condo. I bought a property. I'm in a small business. It's not making money. So you got to listen to that episode, the Corporate Transparency Act, also with Lawrence Lambert. And now, Lawrence, how are you doing today?
I'm doing great.
All right.
Very excited to talk to you about this non-compete issue because it's really interesting and very controversial.
Yeah. So let's start it off with why were there non-competes in the first place?
Well, that is a historical question. I mean, non-competes have been used for hundreds of years. The purpose of them really is for businesses to be able to protect their confidential information, to protect their customer relationships, their vendor information, things that are very unique and specific to their business that makes them unique and different in the market and helps them to be successful. So businesses spend a lot of time and money training their employees, building relationships with their customers, and they don't want people to come in, work at the business for a couple of years, learn all that information, and then go off and steal the business by opening their own business or working for a competitor. So the purpose of a non-compete is generally been very prominent and prevalent in business operations for a long time. Some states like California have severely restricted non-competes for a long time. I think California's restrictions have been in place for almost 100 years. So California has sort of been out on its own in limiting non-competes. Other states in more recent years have also been moving in that direction. But Florida, for instance, has a very robust law that protects non-competes and ensures that they are enforceable if they meet certain criteria. So this change really has a significant impact, particularly in the state of Florida.
All right. So just to be lawyers for a second, legalistically, we're talking about the FTC issues a regulation saying no more non-competes, and then
right.
they have certain exceptions and all that. Is that
correct?
All right.
That's basically it. Yes.
And just for those that don't know, the FTC stands for
Federal Trade Commission.
Okay. And so they're a federal agency.
Correct.
And their rule, so Florida's robust protections for non-competes are now out the window?
Until a federal court or the Federal Trade Commission or Congress steps in and stops this rule, yes, the Florida laws will no longer be effective in protecting the enforceability of non-competes.
All right. And when did this rule come into play?
It hasn't yet. The projected effective date of the new rule is September 4th. And I believe it then has a 90-day period for businesses to get in compliance before it becomes enforceable through legal action against violators. So the effective date of the rule, the last I checked, was September 4th, and then there's I believe it's a 90-day period during which you're given an opportunity to get into compliance.
Gotcha. All right. And so should we expect a legal challenge to this rule?
Oh, expect. It's already, there are already several cases that have been filed. I'm not aware as of today of any courts issuing any injunctions, putting a hold on the rule. I would not be surprised if one is entered, particularly one of the main cases is pending in Dallas, Texas. And I would not be surprised if that court imposes an initial preliminary or temporary injunction while that case is litigated to put a hold on the rule. Whether or not the injunction will be nationwide or just limited to the parties in that case, I don't know, but I would not be surprised to see some sort of an injunction imposed.
Yeah. So what this boils down to is almost like employees' rights versus the employer's rights.
Exactly. So the if you read the 100 pages of justification that the FTC filed as part of the reason for this rule, it really does come down to trying to free up the economy as a whole for better competition, better wages, and more freedom of economic rights amongst individuals, as opposed to allowing all of the economic control and competitive limitations being given to the existing companies. So they did studies as part of their rulemaking process to determine how much additional economic development would this result in, and they determined that billions of dollars of additional economic development would be possible if we ban these non-competes. It'll be a huge impact on raising wages, because as you can imagine, if you go work for a company and you have a non-compete, you can't go do the same thing you are doing for that company anywhere else. That means they can sort of control your wages and keep them perhaps quote unquote artificially low because they know you can't go somewhere else and do the same thing. So without that non-compete, it puts a pressure on employers to raise wages for employees to keep them, because now they can leave and go work elsewhere in a competitive way and make more money. So there's going to be an upward pressure on wages, is the theory, and therefore help employees gain a little bit more power in the workplace.
All right. Let's say the rule goes into effect as it's written now.
Mm-hmm.
Does this cover everybody? Does this cover people that already have non-competes? Does this cover like high-level employees, low-level, depending upon the business?
Yeah, it's a great question. So it's sort of bifurcated. As of the effective date of the rule, every existing non-compete, other than for people called, quote, senior executives, is no longer effective. So and the big example that people give for why this rule was needed is you have like hairdressers and fast food restaurants having these non-competes in place, right? Those are the people that are most negatively impacted and arguably unnecessarily impacted by a non-compete. Everybody in that position will no longer be barred from working for a competitor. So it's every low-level worker, every middle management worker that has a non-compete will no longer be subject to that non-compete as of the effective date. For senior executives, if you have an existing non-compete, that existing non-compete will continue. You'll still be subject to it. However, this is where the bifurcation comes in. All new employment arrangements, even for senior executives, so if you leave your company and you go work somewhere else, let's say after your existing non-compete expires, that new job, they cannot require you to have a non-compete, even if you're a senior executive going forward into the future.
Yeah.
So, the idea is that eventually there will be no non-competes at all, except in limited circumstances related to like a sale of a business. So if you engage in a merger or sell your business, non-competes will still be permitted in those scenarios. But for general employment relationships, no more non-competes.
Yeah.
I mean, that's basically the to cut to the chase. It's pretty much everyone.
Pretty much. Yeah. All right. So the corporations, the businesses that, I mean, I think there's, like you talk about, like the fast food employee that's, has a non-compete and they can't oh my God, I need to move. I don't like my boss. I have another opportunity. And the fact they can't, I mean, that's kind of
Yep.
ridiculous. But so for some companies that, hire some, person to develop the nuclear missile or whatever, and you don't, that's a little bit different, and maybe there's some legitimacy to the reason why you have a non-compete.
Mhm.
So from my perspective, I see that there's a little bit of like, well, how are these corporations that have legitimate concerns that they hire
Yeah.
employees who are going to steal like really, really valuable information and go and start their
Yeah.
own business and just completely undercut you. And, thanks for
Right.
years of paying my salary. Now I know how to do all this or whatever, and I'm gonna, put you out of business.
Well, that scenario actually isn't covered by the rule. So let's be clear, when we're talking about a non-compete, it's really limited to an actual non-compete, which means you are allowed to go and work for a competitor, but it doesn't protect you against confidentiality agreements and non-solicitation agreements. So businesses can still use trade secret protection. So if you've got a unique process for your business, like nuclear warhead development in your example, and that is highly regulated, protected, secret information, you can still have a confidentiality agreement that bars you from taking that information and going to a competitor and using that information.
Okay, yeah,
So that is still
in
allowed,
effect, yeah,
as is non-solicitation, where you can prohibit your employees from going to work for a competitor and then soliciting to steal your existing clients away. Right?
yeah,
That is still, those kind of agreements are still enforceable. There is some room in the law for arguments that if your non-solicitation is so comprehensive that it effectively acts as a full-on non-compete, that it may not be fully enforceable going
yeah,
forward under the new rule. But for just a general non-solicitation or confidentiality, those things still apply.
yeah,
So if you are an employee and you're thinking, ooh, this is my chance, I can steal all my customers and bring them to a competitor, no, they'll still be sued. That's not going to be allowed. But you can go work for the competitor. You just can't solicit your existing, client relations from your first employer.
yeah, which seems to be prevalent in our industry, but we'll save that for another discussion. All right, so all right, so let's say I'm an employee, making $70,000. I signed some agreement with I signed an employment agreement when I started. It was all this legalese, and I just did it. Are the non-competes typically or often, frequently, included in your like big employment agreement, and people aren't even
Uh,
aware that they signed it?
It can be. I mean, that's not totally unusual as part of to the extent that a company uses an employment agreement. Uh, Usually the purpose of it would be to have that kind of a non-compete, non-solicitation, and confidentiality agreement.
Yeah,
Which is why it's so strange that you have, like these low hourly wage, service employees signing employment agreements like that. That historically, you'd file an application with McDonald's, you get a job, they put you on the payroll, uh, you fill out a W-4, and then you're done. But
yeah,
now, they have these agreements, and the only real reason for them is to have these kind of non-compete provisions.
yeah,
So yes, it's not uncommon that there'll be it'll be wrapped into a larger agreement. It may also be a standalone agreement. A lot of people don't read them, don't really understand them. They sign them, and they don't even know. Which is why the rule, in addition to simply, making those rules or those pre-existing agreements unenforceable, there's an additional obligation put on employers that they have to notify both their current employees and former employees who are subject to non-competes, that those non-competes are no longer enforceable. So once this rule goes into effect, and assuming that there's no court imposed injunction, employers are going to have to go back and send out these notices to their existing and former employees that their non-competes are no longer enforceable, and effectively that they're allowed to now go work for competitors.
And what's the penalty for those employers that don't do that?
You
Or
could
is
you
there?
could either be you could be sued by the Federal Trade Commission for violation of the ruling of the rule, or the employee or employer can sue the company for violating the rule. Uh, I'm not sure what the financial penalties are for violations. It could be just regular damages that they're prohibiting you from taking jobs and
Yeah.
losing income or things like that. But there may be a statutory fine involved as well. Honestly, I'm not sure what that is. I don't recall seeing it when I read through the new rule, but I can go back and give you a little addendum afterwards with that if there is some sort of a fine involved.
All right, so we will put that in our show notes. We'll
Mhm.
clear that up. But all right, let's get back to senior executives. Do they define it? Define what a senior executive is?
Yes, so a senior executive, uh, and there's going to be years of litigation over this, I'm sure, because as with any rule or statute, no matter how careful you try to be in your definitions, there's always room for interpretation. But at its core, a senior executive is someone who's in a policy making position. So policy making position with the employer, and whose total annualized compensation in the preceding year was at least $151,164.
Gotcha. And would that,
So
yeah,
a senior policy making position, that's an issue that will be up for some interpretation. Certainly, it would be anyone who's a corporate officer, almost certainly would apply. Corporate officers, it could also be like division managers. So if you have a big corporation with multiple divisions, the head of a division may be considered a senior executive as long as they're making at least $151,164.
okay. So I just want to kind of go back to the non-solicitation um, issue. All right. So you're
Mhm.
in you've signed a non-compete. You have some, hey, you can't steal the clients. You got some confidentiality provision, and you want to leave, and you actually do want to solicit some of the clients because, maybe they were all your clients to begin with, and somehow or another,
Right.
the non-solicitation you look at is a little bit unfair, and maybe the employer, maybe they owe you something or whatever. Are these things that, okay, you're coming to grips with the fact that you want to leave, you got this non-solicitation, it's gonna really restrict you. Can you go back to your employer and negotiate and say, hey, you know what, I signed this, I didn't even know what I was signing, and it's so unfair, and I made you so much money, let me out for
Well, yeah,
$100,000
yeah,
like that.
of course. I mean, that has always been allowed. I mean, even before this rule, it was not uncommon for an employee to go to the employer and say, "Hey, I have an opportunity. I'd really like to do it. Will you let me out of my non-compete?" And a lot of times, the company that you're looking to go work for will help facilitate that by maybe agreeing to pay a buyout
Yeah.
amount to let you out of your non-compete. So those things have always been, possible. It just depends on the nature and scope of what kind of competition we're talking about. But yes, you can certainly try to do that, and a lot of times it's very successful. People are able to get out of their non-competes with a
Yeah.
little negotiation.
Yeah. A little money
So,
go a long way.
well, money helps, but sometimes look, employers recognize that the likelihood of a significant impact on their business is very minimal,
Yeah.
and you know they're willing to let you out even if they don't get paid, for it. And especially if like you're moving to another location, and it's their footprint in that location is minimal. They may not care so much. So,
Yeah.
so I certainly encourage any employee who wants to leave. It doesn't hurt to ask, but if once you ask, remember they now know.
Yeah.
So once your current employer knows that you're looking to leave, if you do then leave, and they may be more attentive to your future actions, and so there's that risk.
All right. So going back, two more questions. Let's just follow up on this, like non-solicitation. What happens if you get fired and you have a non-solicitation?
You're still subject to it,
Yeah.
unless your agreement provides that if you're fired, you're relieved from it.
Yeah.
So, that doesn't being fired doesn't protect you from the enforcement of a non-solicitation or not. Well, now a non-compete will be banned, but a non-solicitation would still apply
Gotcha.
unless it provides otherwise, or unless you can argue that the firing was wrongful, right? So then you could argue that if the employer breached your employment agreement, that arguably that would relieve you from any further obligations under the employment agreement.
Yeah.
But if it was a legitimate firing, or even just you're being let go because they're reducing, downsizing, you're still subject to your non-compete or your non-solicitation and confidentiality.
Gotcha. All right. Last question, unless you think there's some things that we did not cover that we need to cover. My last question is going back to the employer's responsibility, if this goes into effect, of notifying their employees that their non-compete is no longer in effect. In the scenario where maybe you signed an employment agreement, you didn't even know that there was a non-compete. Do they have to, in their notice, can they just like send out a blanket notice to all employees? Hey, if you have a non-compete with us, it's no longer in effect? Or do they have to actually say to you, Lawrence, you have a non-compete, and guess what? You no longer, are required to live by it.
The FTC has approved a specific form that employers can use. That's available. If you go to the ftc.gov website, you can find the link there, and you can download that form to use as a basic template. Yeah, I mean, you've got to tell, even if they don't know that they have it, you got to tell them that they had it and they're no longer subject to it. I will say that there is some protection for employers that, for former employees, for instance, maybe you don't know where they are, you don't have a current address, or you don't know if you have a current address. You're not obligated to do a nationwide search for all your former employees. You're allowed to use whatever the last known best contact information that you have to send that notice. So if the employee has left and you don't know where they are, as long as you send it out to your last known address or email address or physical address, that's sufficient. So they don't put a search obligation on the employers. Gotcha. And I do want to correct one thing. When I said earlier that it's a 90-day period for compliance, it's actually 120 days. I want to fix that.
Gotcha.
It's 100. You have 120 days from the date the final rule goes into effect to get into compliance.
All right, and we're projecting that to be in September, the final rule to get into effect.
Correct. September 4th, I believe, is the projected date of the final rule. Yes.
All right. So, do we miss anything valuable, important that we need?
Yes. The only other thing I would advise is, if you are currently an employee subject to a non-compete and you are currently in violation of that non-compete, you can still be sued for enforcement. The ban only takes place as of the effective date of the rule. So if you're already violating a non-compete, you can still be subject to enforcement of that non-compete for violations that occur prior to the effective date of the new rule. Yeah. So don't jump the gun. Yeah. Because you could still be sued for your actions that you do before the new rule goes into effect.
Gotcha. All right. Well, thanks for coming on and giving us both part one, which was Corporate Transparency Act, the beneficial ownership. Do you have to do your reporting and when? And now the non-competes, which is going to be very big. And so there's going to be legal challenges. So how these things play out, we'll find out, and we'll bring you back on and we'll get an update, down the road from you, Lawrence. All right.
Happy to do it. And just again, a reminder, if anybody's interested in reading the actual rule, you just go to the ftc.gov website. There's a huge prominent link right at the front page there to read all about it.
Yeah, and that might solve some insomnia for some of you, my audience here that
exactly
suffering from that. So, not only do we provide the law and entertainment, interesting people, but we give you antidotes for insomnia. All right, that'll do it for this. That'll help. All right, yeah. So, all right, that'll do it for this episode of this two-part episode of Cut to the Chase. Thank you, Lawrence Lambert, business lawyer in Miami, South Miami or Miami?
Miami. All of Dade County for sure.
All right.
As well as the whole state. So
we'll put a link in the show notes so you can see how to get in contact with Lawrence. But just out of curiosity, what's the easiest way to get in contact with you? Somebody's got a question, whatever.
Easiest way is to shoot me an email at my first name, initial L, followed by my last name, Lambert. So Lambert at llambertlaw.com.
All right, folks, you heard it there. Thank you again, Lawrence, and have a good day. That'll do.
All right, thanks, Greg. Good to talk to you.
That'll do it for this episode of Cut to the Chase. Since I'm going to bring Lawrence back, if you got any questions related to these topics or other small business topics you would like him to cover, let me know. You go to my YouTube page and, with the comments, you can put them in there if you liked us, if you didn't, whatever you want to say. All right, everybody, have a good day.
That's all for this episode of Cut to the Chase. But before you go, will you open up your podcast app and give us a 5-star review? You can also leave a comment about what you liked most or other topics you'd like us to cover. And please be sure to subscribe so you don't miss any upcoming shows. Thanks, everybody. Be safe out there.